Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. We come to you today with breaking news. Today, February 20th, 2026, the Supreme Court issued an opinion in the Trump Tariffs cases. That's Learning Resources versus Trump and Trump versus V.O.S. Selections. We've been tracking this blockbuster case for months. It's finally out. The Supreme Court ruled 6-3 that President Trump lacked the legal authority to impose his sweeping tariffs. The court said the emergency powers law he relied on, something called IEEPA, simply doesn't give the president power to tax imports. Justice Roberts wrote the majority decision. He commanded a 6-3 majority for most of the opinion. 7 of the 9 justices wrote opinions in this case. The only 2 that didn't were Justices Alito and Sotomayor.
Let's quickly give our audience the too long didn't read version of the multiple opinions and then break them down in greater detail. The majority held that the Constitution gives Congress alone the power to tax, and tariffs represent a tax on imports. IEEPA's authority to regulate importation lets the president control, restrict, or block foreign transactions. But it never gave him power to reach into Americans' pockets by imposing taxes Congress never authorized. Justice Roberts grounded this decision in the major questions doctrine and on statutory interpretation grounds. Justices Kagan, Sotomayor, Gorsuch, Barrett, and Jackson joined for all portions, except the major questions doctrine analysis. That section only garnered 3 votes: Chief Justice Roberts, Justice Gorsuch, and Justice Barrett.
Justices Gorsuch, Barrett, Kagan, and Jackson all wrote separate opinions concurring in the judgment. Justice Thomas and Justice Kavanaugh each wrote dissenting opinions. Justices Thomas and Alito joined Justice Kavanaugh's dissent.
Justice Gorsuch's separate opinion focused on the major questions doctrine. He wrote that the major questions doctrine protects Congress's lawmaking power by requiring clear authorization before the president can claim extraordinary authority. And that principle traces back centuries through English and American law. When Congress wants to hand over its most fundamental power, the power to tax, it must speak clearly. And IEEPA's generic emergency language falls far short.
Justice Barrett's concurring opinion wrote about the major questions doctrine too. She emphasized that the major questions doctrine simply reflects ordinary interpretation informed by constitutional structure, not some special thumb on the scale against executive power.
Justice Kagan wrote that the court did not need to use the major questions doctrine. Regulate simply doesn't mean tax in any dictionary, any statute, or any universe where words retain their ordinary meaning. When Congress actually delegates tariff power, it uses words like duty and surcharge and imposes strict limits. IEEPA does none of that.
Justice Jackson wrote to highlight legislative history. She stated that the official congressional reports accompanying IEEPA describe the law as granting freezing control authority over foreign property, not power to tax imports. Courts should examine what Congress actually said it intended, not speculate about what makes sense to judges decades later.
Justice Kavanaugh wrote the primary dissent. He opined that text, history, and precedent all confirm that regulate importation includes tariffs. President Nixon used identical language for worldwide tariffs in 1971. Courts upheld it. And Congress copied that exact phrase into IEEPA 6 years later. The court's decision extends the major questions doctrine into foreign affairs for the first time, potentially handcuffing future presidents when America faces genuine emergencies requiring rapid trade responses.
And Justice Thomas wrote about the non-delegation doctrine. Thomas stated that the Constitution only prevents Congress from delegating core legislative power over life, liberty, and property. Regulating foreign trade involves privileges the government grants, not fundamental rights it must protect. Congress can freely delegate tariff authority to the president, and it did so through IEEPA's broad emergency powers.
Wow, that's a lot to unpack. Before we dive deeper, let me pause here to remind you to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, let's unpack the decision. Let's peek at the page counts because that tells its own tale. The decision totaled 170 pages. The majority opinion spanned 21 pages. Justice Gorsuch's opinion spanned 46 pages. Justices Barrett, Kagan, and Jackson's separate opinions collectively totaled 16 pages. Justice Thomas's dissent totaled 18 pages, and Justice Kavanaugh's dissent totaled 63 pages. That breakdown shows how fractured even the winning coalition became. 6 justices agreed the president lost, but they couldn't agree on why. Gorsuch needed 46 pages to defend a doctrine 3 of his allies refused to join. And the dissenters felt so strongly they wrote 81 pages, combined explaining why the majority got it wrong. When a 21-page majority spawns 149 pages of separate writings, the justices view this case as a battleground for much bigger fights about presidential power, emergency authority, and how courts should read statutes for decades to come.
So true. We all know how we got there. But let's quickly recap the timeline because it factored heavily into the decision. Shortly after taking office, President Trump pointed to 2 problems he called national emergencies. First, illegal drugs flowing in from Canada, Mexico, and China. Second, America buying way more from other countries than we sell to them, what economists call trade deficits.
And he declared both situations emergencies under federal law.
Right. He then reached for a 1977 law called the International Emergency Economic Powers Act. We'll call it IEEPA. That law gives presidents tools to respond to foreign threats during emergencies. The president said IEEPA let him impose tariffs, so he did. 25% on most goods from Canada and Mexico. Initially, 10% on Chinese goods.
But the China number didn't stay at 10%.
Over just a few months, the president raised the China rate to 20%, then 84%, then 125%. Add that to other existing charges, and importers faced a total rate of 145% on most Chinese goods. And he imposed at least 10% tariffs on imports from every trading partner worldwide.
Dozens of nations faced even higher rates, and these tariffs applied even when we already had trade agreements promising lower rates. And the changes kept coming. Rate increases one week, exemptions the next, then he'd reverse course again.
2 groups sued to stop these tariffs. Learning Resources, a couple of small businesses, filed in Washington, D.C. V.O.S. selections, 5 small businesses plus 12 state governments, filed in a specialized trade court. Both courts ruled against the president. The D.C. court blocked the tariffs temporarily. The trade court ruled them unlawful. Then a federal appeals court agreed. The law the president cited simply doesn't authorize tariffs without any limits on how much, how long, or how broad.
The appeals court split right down the middle on the reasoning, which tells you how genuinely contested this question became. The Supreme Court took up both cases together on a fast track
And ruled against the president, 6-3.
Let's now talk opinions. Chief Justice Roberts' majority opinion began with the origin of the power to tax. The Constitution, Article 1, Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises.
Notice who gets that power. Congress, not the president. The founders put taxing power first among Congress's listed powers for a reason. Alexander Hamilton called it the most important power the new federal government would hold.
And remember why we fought the revolution in the first place.
No taxation without representation. The colonists believed only their elected representatives could tax them. Not the king, not even Parliament sitting an ocean away. So when the founders wrote the Constitution, they gave taxing power exclusively to Congress, the branch closest to the voters.
Where do tariffs fit into this?
Chief Justice Roberts quoted a ruling from 1824. Tariffs represent very clearly a branch of the taxing power. A tariff amounts to a tax on imported goods. It raises money for the government. That makes it a tax, period.
And taxes belong to Congress. So the whole case boiled down to one question. Did Congress give the president tariff power through IEEPA?
6 justices said no.
Let's look at what this law actually authorizes. IEEPA lets the president take certain actions when he declares a foreign threat rises to the level of a national emergency. The law lists 9 things the president can do: investigate, block, regulate, direct and compel, nullify, void, prevent, or prohibit. And it lists 11 types of transactions he can target: importing, exporting, transferring property, and so on.
Mix and match those, and you get 99 different actions a president can take.
Here's the critical point. Not one of those 99 combinations mentions tariffs, duties, or taxes. The word tariff appears nowhere in IEEPA. Neither does duty or tax.
So where did the president claim authority came from?
2 words buried in that list: regulate and importation. The president argued that power to regulate importation includes power to tax imports.
And the court said?
No way. Regulate means to control, adjust, direct, or set rules for something. It doesn't mean to tax it.
Can you give an example?
Sure. The Securities and Exchange Commission, the SEC, holds power to regulate the trading of securities. Nobody thinks that means the SEC can impose a tax every time someone buys a stock. The SEC can set rules for trading. It can block certain trades, but it can't send you a tax bill.
So regulate and tax mean different things.
The government's lawyers couldn't name a single law anywhere in the entire federal code where regulate includes the power to tax. And when Congress actually wants to give the president tariff power, it uses completely different language. Words like duty or surcharge or import fee. It sets caps on how high the rates can go. It limits how long the tariffs can last. It requires investigations, public hearings, and official reports before the president can act. IEEPA contains none of that.
None of it. No rate caps, no time limits, no required studies. If regulate importation meant impose any tariff you want, the president could tax imports at 1,000% forever. Based solely on emergencies he himself declares. That's a breathtaking amount of power.
Too breathtaking, according to 6 justices who reasoned that Congress doesn't hand over its most fundamental power, the power to tax, through vague language buried in an emergency statute.
Now, here's where the justices split among themselves, even the ones who voted against the president. 3 justices, Chief Justice Roberts, Justice Gorsuch, and Justice Barrett, relied on something lawyers call the major questions doctrine. In plain English, that principle says, when the president claims some enormous, unprecedented power, he needs crystal clear permission from Congress. Ambiguous language won't cut it.
What made this a major question?
The sheer scale. This is where the timeline we ran through came into play. The government bragged these tariffs would reduce the national deficit by $4 trillion. Trade deals negotiated using tariff leverage could total $15 trillion. Compare that to other cases where the court applied this principle: $430 billion for student loans, $50 billion for eviction moratoriums.
This dwarfs those.
And no president in IEEPA's entire 50-year history ever claimed the law authorized tariffs. Presidents invoked IEEPA constantly for other things: freezing foreign assets, blocking transactions, imposing sanctions. But for tariffs, they always used different laws.
So if the power existed, why did nobody use it for half a century?
Exactly the question Roberts asked. That lack of historical precedent, coupled with the breadth of authority the president now claimed, signals the power probably doesn't exist.
But 3 other justices in the majority didn't sign on to this reasoning?
Right. Justices Kagan, Sotomayor, and Jackson agreed the tariffs violated the law, but they refused to join the major questions section. Justice Kagan wrote separately to say ordinary interpretation already dooms the tariffs. You don't need any special thumb on the scale.
Her point?
Regulate simply doesn't mean tax. Look it up in any dictionary. Check how Congress uses the word everywhere else in federal law. You reach the same answer without needing any fancy doctrine.
So 6 justices agreed on the destination, but took slightly different roads to get there.
Exactly. 3 said the major questions doctrine requires clear authorization the president can't provide. 3 said you don't even need that doctrine. The text alone kills the tariffs.
Let's dig deeper into why the court said regulate importation can't mean tax imports.
Roberts made several points. If Congress really wanted to hand over the power to rewrite the entire tax code for the global economy, they wouldn't hide it inside a vague word like regulate. They would have put it in neon lights.
Next, he looked at IEEPA's full list of powers. The president can investigate, block, regulate, direct, and compel, nullify, void, prevent, or prohibit various transactions.
9 different verbs.
Every single one describes ways to control, restrict, or stop foreign transactions. Block imports, prohibit transfers, nullify contracts, void agreements. These represent tools to squeeze foreign actors economically. Sanctions, freezes, bans.
None of them raise money for the Treasury.
Exactly. Tariffs operate completely differently. They don't block goods from entering. They charge a fee for entry. The money goes straight to the federal government. That's taxation, not regulation.
So tariffs stick out like a sore thumb compared to everything else IEEPA authorizes.
Roberts called it the odd man out, the only one of 99 permission slips to involve the core congressional power of the purse.
You mentioned another textual problem, something about exports.
IEEPA authorizes the president to regulate importation or exportation. Import and export, same treatment. So if regulate means tax,
Then IEEPA authorizes the president to tax exports too. But here's the problem. The Constitution explicitly forbids taxing exports. Article 1. Section 9 says, "No tax or duty shall be laid on articles exported from any state."
so reading regulate to mean tax would make IEEPA partly unconstitutional. The court prefers readings that avoid constitutional problems. Reading regulate to exclude taxation solves that problem cleanly.
The dissenters made a big deal about President Nixon. Quick aside, what happened there?
In 1971, Nixon imposed 10% tariffs on virtually all imports worldwide. He claimed authority under TWEA, the Trading with the Enemy Act, which became IEEPA's predecessor. TWEA contained the exact same regulate importation language.
And courts upheld Nixon's tariffs?
One appeals court did. The government argued Congress enacted IEEPA in 1977, knowing about Nixon's tariffs and that court ruling. So Congress must have intended the same language to carry the same meaning.
What did the majority say to that?
Not buying it. One appeals court decision from a specialized trade court doesn't establish a well-settled meaning that Congress definitely adopted. And the question isn't what one court said, it's what the statutory text actually means.
The dissenters saw it differently?
Very differently. Justice Kavanaugh argued any reasonable person in 1977 would have understood regulate importation to include tariffs. Nixon just used that exact language for worldwide tariffs. A court upheld it. Then Congress passed IEEPA using identical words. If Congress wanted to exclude tariffs, why keep the same language Nixon just invoked?
He also pointed to President Ford. In 1975, Ford imposed fees on oil imports using similar statutory language. Adjust the imports. The Supreme Court unanimously upheld those fees in a case called Algonquin.
So Kavanaugh's argument runs, adjust the imports means the same thing as regulate importation. If one includes tariffs, so does the other.
The majority distinguished Algonquin based on differences in statutory language and structure. But Kavanaugh called that distinction unconvincing.
Let's move now to the concurring opinions. Justice Gorsuch wrote a lengthy, separate opinion. What did he add?
Gorsuch joined the Chief Justice's full opinion, but wanted to defend the major questions doctrine against criticism. Some justices, Kagan, Sotomayor, Jackson, attacked that doctrine in past cases as a judicial invention that blocks agencies from doing important work.
But those same justices voted against the president here.
Gorsuch noticed that too. He argued they all but endorse the major questions doctrine now, even if they won't use the label. Kagan's opinion applies the same factors: unprecedented power, no historical precedent, common sense about what Congress would delegate, just without calling it major questions.
So Gorsuch sees them as converts?
He'd like them to be. He traced the principle back centuries. to English corporate law, agency law, cases about when delegates can exercise extraordinary powers. The rule always required clear authorization for unusual actions. Courts didn't let agents claim sweeping powers based on vague instructions.
And Gorsuch thinks that principle protects Congress's power.
Exactly. Once the court reads a doubtful statute to grant the president some enormous power, Congress struggles to take it back. Any president who likes having that power will veto legislation retrieving it. You need a two-thirds supermajority in both chambers to override a veto.
So powers flow to the president and get stuck there. Without doctrines requiring clear authorization, Gorsuch warned, our system of separated powers threatens to give way to the continual and permanent accretion of power in the hands of one man.
Justice Barrett also wrote separately. How did her view differ?
Barrett joined the full opinion but expressed discomfort with calling the major questions doctrine a special clear statement rule. She prefers describing it as ordinary interpretation informed by context and common sense.
What's the difference?
A clear statement rule actively loads the dice against certain interpretations. It requires magic words or something close. Barrett resists that framing. She thinks courts simply read statutory text in context, including constitutional context. A reasonable reader expects Congress to make big decisions itself rather than handing them off.
So she reaches the same result but describes the method differently?
Right. Gorsuch pushed back, arguing Barrett's common sense approach can't explain all the major questions cases. Sometimes the text could plausibly support the government's reading under ordinary interpretation. But the court still rules against the government because the claimed power seems too enormous.
An interesting debate among allies.
They agree the president loses. They disagree somewhat about how to describe why.
Justice Kagan, joined by Justices Sotomayor and Jackson, took yet another approach.
Kagan has criticized the major questions doctrine before. She once called it a special canon that magically appeared to stop agencies from doing important work. She said you don't need any special doctrine. Ordinary interpretation already kills the tariffs. Regulate doesn't mean tax, not in any dictionary, not anywhere in federal law.
So she applied standard tools and reached the same destination.
Exactly. She emphasized several points the full majority also made. IEEPA's 99 authorized actions all involve controlling or restricting foreign transactions. None involve raising revenue. When Congress actually delegates tariff power, it uses specific vocabulary and imposes strict limits. No president in 50 years ever found tariff power in IEEPA.
All those facts point the same direction without needing any thumb on the scale. Kagan also noted a practical absurdity. If IEEPA authorizes unlimited tariffs, the president could escape every limit in every other tariff law simply by declaring an emergency. That would effectively erase decades of carefully crafted trade legislation.
Congress couldn't have intended that.
Kagan's bottom line, ordinary principles of statutory interpretation lead to the same result. No major questions, doctrine required.
Justice Jackson wrote her own separate opinion. What did she add?
Jackson agreed the tariffs violate the law, but criticized both the majority and dissent for ignoring the best evidence of what Congress sought to accomplish.
What evidence?
The official reports Congress wrote when passing these laws. When Congress considers legislation, committees in the House and Senate produce reports explaining what the law does and why. Jackson argued these reports represent the most reliable source for congressional intent.
What do the reports say about IEEPA?
The Senate report described the law's purpose as granting emergency authority to control or freeze property transactions where a foreign interest exists. The House report similarly described power to regulate or freeze foreign property.
Freeze and control, not tax.
Neither report mentions tariffs. Both describe the law as giving presidents tools to freeze assets and control transactions. Sanctions-type powers, not taxation powers.
So the people who wrote the law never thought it authorized tariffs.
Jackson's point exactly. Instead of speculating about what Congress would have intended, courts should examine what Congress actually said it intended.
Now let's hear from the losing side. Justice Kavanaugh wrote the main dissent, joined by Justices Thomas and Alito. Kavanaugh opened by declaring that in any ordinary case, the court would flatly reject the plaintiff's exceedingly weak statutory arguments.
Strong words.
He argued text, history, and precedent all clearly establish IEEPA authorizes tariffs. Start with what regulate historically meant. Chief Justice Marshall, Justice Story, James Madison all recognized that regulating foreign commerce includes imposing tariffs. Marshall wrote in 1824 that the commerce power comprehends every species of commercial intercourse, including tariffs to encourage domestic manufacturing.
So the founders understood regulate to include tariff.
Kavanaugh also hammered the Nixon precedent. In 1971, Nixon imposed 10% tariffs on essentially all imports, using the exact same regulate importation language. Courts upheld those tariffs. Then, Congress passed IEEPA in 1977 using identical words.
And Kavanaugh's point?
If Congress wanted to exclude tariffs from IEEPA, why would it copy-paste the exact language Nixon just used for tariffs? Any reasonable person in 1977 would have understood regulate importation to include the power Nixon just exercised.
What about the Algonquin case, the Ford oil fees?
Kavanaugh emphasized that decision heavily. In 1976, just 1 year before IEEPA, the Supreme Court unanimously ruled that adjust the imports includes monetary charges like fees. The plaintiffs there made the exact same arguments the plaintiffs made here. The statute doesn't say tariff, so it can't authorize tariffs.
And the court rejected that?
Unanimously. It found no support for limiting adjust the imports to quotas rather than fees. Kavanaugh argued the same logic applies here. Adjust and regulate mean essentially the same thing. The dictionary definition of regulate even includes adjust by rule.
Kavanaugh also made a common sense argument.
A powerful one. Everyone agrees IEEPA authorizes the president to impose quotas, limits on how many goods can enter. Everyone agrees he can impose total embargoes, complete bans on imports from certain countries.
So he can block goods entirely.
Right. But under the majority's reading, the president can block every single product from China during an emergency, but he can't charge even a $1 fee on those same products.
That does seem backwards.
Kavanaugh called it nonsensical. Tariffs represent a less extreme tool than quotas or embargoes. They discourage imports without banning them entirely. If IEEPA authorizes the nuclear option, complete blockade, why wouldn't it authorize the milder option of charging fees?
The majority's response?
Tariffs differ in kind, not degree. Blocking imports controls foreign commerce. Taxing imports raises revenue. They represent fundamentally different categories of government action. The Constitution assigns them to different branches.
So the majority sees it as apples and oranges, while Kavanaugh sees it as a spectrum from mild to severe.
Kavanaugh also argued courts should treat foreign affairs laws differently.
This represents maybe his most important argument for future cases. The Supreme Court has never before applied the major questions doctrine to a foreign affairs statute. Kavanaugh urged the court not to start now.
Why treat foreign affairs differently?
2 reasons. First, the Constitution itself treats foreign and domestic affairs differently. The president holds significant independent powers over foreign policy, negotiating with other nations, commanding the military, receiving ambassadors. Courts have long recognized Congress can delegate more broadly in foreign affairs because situations change rapidly, and the president needs flexibility.
So Congress intentionally gives presidents more room to maneuver abroad.
Second, the whole premise of the major questions doctrine assumes Congress wants to make big-time policy calls itself. But in foreign affairs, Congress often deliberately hands the president wide discretion. That's not Congress failing to speak clearly. That's Congress intentionally empowering the president.
So the doctrine's assumptions don't fit.
Kavanaugh cited 2 major precedents. First, Hamdi, the enemy combatant detention case after 9/11. Congress authorized all necessary and appropriate force against terrorists. That language doesn't mention detention, but the court said it clearly authorized detaining enemy fighters because detention represents a traditional tool of warfare.
The court didn't require magic words.
Right. Second, Dames and Moore, the Iran hostage crisis case. President Reagan suspended American lawsuits against Iran as part of the deal to free hostages. The court admitted IEEPA didn't clearly authorize that action, but it upheld the suspension anyway, based on the general tenor of congressional legislation and long-standing presidential practice.
General tenor sounds way less demanding than clear authorization.
Exactly Kavanaugh's point. If the court had applied the major questions doctrine in those cases, the outcomes would flip. Enemy detention, unlawful. Hostage settlement, unlawful.
Kavanaugh worries today's decision could hamstring future presidents in actual crises.
That's his fear. Extending the major questions doctrine into foreign affairs for the first time creates uncertainty about what tools presidents can use going forward.
Kavanaugh also raised practical concerns about the decision's aftermath.
Big ones. The government collected billions of dollars under these tariffs. Now what? The court said nothing about refunds, but importers will demand their money back.
That could cost the Treasury enormously.
At oral argument, even the justices acknowledged this could create a mess. And what about trade deals negotiated using these tariffs as leverage? The government claimed deals with China, the UK, Japan, and others, worth trillions of dollars, resulted from tariff pressure.
Do those deals fall apart now?
Uncertain. The legal and economic fallout could take years to sort out.
But Kavanaugh noted the president might still impose tariffs through other laws.
Right. Section 232 lets the president adjust imports to protect national security. Section 301 targets unfair trade practices. Section 201 addresses industries injured by imports. These laws explicitly mention tariffs and contain various safeguards.
So the president isn't completely powerless.
But those laws impose limits, rate caps, time restrictions, required investigations. The president can't simply declare an emergency and do whatever he wants. He'd need to follow the procedures Congress built in.
Justice Thomas joined Kavanaugh's dissent, but also wrote separately. What did he add?
Thomas advanced a sweeping theory about what powers Congress can delegate to the president.
Give me the plain English version.
Thomas argued the Constitution only prevents Congress from delegating core legislative power, meaning the power to make rules that take away people's life, liberty, or property. Think criminal laws that send you to prison or tax laws that take your money. Those powers Congress must keep for itself. But the Constitution also gives Congress powers that don't involve depriving people of fundamental rights, regulating foreign trade, establishing post offices, borrowing money. Thomas argued Congress can delegate those powers freely because they don't trigger the same constitutional concerns.
Where do tariffs fit?
Thomas argued importing goods represents a privilege the government grants, not a fundamental right you possess. Historically, kings held power over foreign trade as a royal prerogative. So Congress can hand tariff authority to the president without constitutional problems.
Gorsuch disagreed.
Strongly. He argued the Constitution doesn't distinguish between core and non-core legislative powers. It vests all legislative powers in Congress, full stop. And even if Thomas's theory held up, it wouldn't help the president here. Congress still needs to actually delegate the power. Theoretical delegability doesn't equal actual delegation.
Let's talk about what this decision actually means for regular people. Several major consequences. First, all the tariffs the president imposed under IEEPA invalid. That covers tariffs on China, Canada, Mexico, and every other country caught in the worldwide tariff net.
Billions of dollars collected. What happens to that money?
Courts will need to sort out refunds. Importers paid these duties expecting they'd have to. Now they'll argue for their money back. The Treasury faces potential liability stretching into the billions.
What about prices consumers already paid?
Harder to unwind. When importers paid tariffs, they passed those costs to customers through higher prices. You probably paid more for imported goods over the past year. That money won't magically return to your wallet.
What about ongoing trade negotiations?
Uncertainty. The government claimed these tariffs produced trade deals worth trillions. Those deals assumed the tariffs would remain in place as leverage. With the tariffs struck down, do trading partners demand renegotiation? Do deals fall apart entirely? Nobody knows yet.
Can the president reimpose tariffs through other laws?
Possibly. As we said, Section 232 lets him adjust imports for national security. Section 301 targets unfair foreign practices, but those laws contain guardrails, investigations, reports, rate limits, Time constraints. The president can't simply announce tariffs on Twitter and call it done, so tariffs remain possible, just through a more constrained process.
Exactly. Congress never eliminated presidential tariff authority. It just never gave unlimited authority through IEEPA. Other statutes provide narrower, more carefully bounded tools.
Stepping back, what does this decision mean for the balance of power between Congress and the president?
It reinforces a fundamental principle. The power to tax belongs to Congress. The founders fought a revolution over that principle. They enshrined it in the Constitution's very first article. The president can't claim taxing power through vague emergency language.
Even during genuine emergencies?
The court didn't say presidents lack emergency powers. IEEPA gives presidents significant tools: freezing assets, blocking transactions, imposing sanctions. But taxing imports requires clearer congressional authorization than regulate importation.
The dissent worries this hamstrings future presidents.
Kavanaugh raised legitimate concerns. Foreign affairs require flexibility. Crises demand rapid response. If courts apply the major questions doctrine to foreign policy statutes, presidents might find their hands tied when America faces genuine threats.
But the majority would respond?
Congress can always grant clear authority. If Congress wants presidents to impose emergency tariffs, it can pass a law explicitly saying so, with whatever limits Congress thinks appropriate. What Congress can't do is accidentally surrender its taxing power through generic emergency language.
Bottom line, time. What should our listeners remember?
3 things. First, the Constitution gives Congress, not the president, the power to tax, including through tariffs. 6 justices agreed the president exceeded his authority.
Second,
The justices who voted against the president disagreed somewhat about why. 3 applied the major questions. Doctrine, demanding clear authorization for enormous claims of power. 3 said ordinary interpretation already kills the tariffs without any special doctrine.
and third,
3 justices dissented. They found clear authorization in text, history, and 50 years of practice. They warned extending the major questions doctrine to foreign affairs could weaken presidential authority in future crises.
that's the Trump Tariffs cases, a landmark decision about who controls the power to tax and whether emergency declarations can unlock unlimited presidential authority. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. Share this episode with one person who thinks Supreme Court cases don't affect their daily life, because every imported product they buy, from their phone to their coffee to their car, just got touched by this decision. Talk to you soon.